So my name is Hersemann. I'm the organizer of CVGLS. I have a solo law practice called Loading Law, where I cater to the needs of folks in tech entrepreneurs and the video game industry. I also teach a course in video game law at DePaul University, and I'd like to turn it over to our panelists to introduce themselves. We'll just go on down the line, and then I'm going to start hitting them with some of your video game law questions that I've taken from Twitter, my own brain, and some things we talked about in this lunch. So Sam, why don't you start us?
All right, my name is Sam Castree. I'm the head of entertainment law at Crawford Intellectual Property. It's an IP boutique here in the Chicago suburbs.
Joe Newman, Privacy and Consumer Protection Counsel, EA News.
Stephen McArthur. I run the McArthur law firm. We're litigation, have a lot of video game clients, but main expertise is lawsuits.
Dave Blair, I'm general counsel at Hi-Rez Studios, makers of Smite and Paladins, and also Skillshot Media, which is our esports group, which works for both ourselves for esports as well as other third-party esport companies.
I'm Bill Ford, an associate professor at the John Marshall Law School, where I teach IP courses, contracts, and video game law as well.
Can we refresh the disclaimer? None of this is
legal advice, it's only legal information, so while it might be informative for you, if you have any specific legal needs, please reach out to your own independent lawyer. You can contact some of our professionals here after the fact, but keep any questions that you have general, hypothetical, and academic. We've had so many great questions here today and so many online, and we've got a full panel with a lot of different unique perspectives, so I think there's a lot of different ways we can attack some of these issues. But one of the hot topics of 2018 has been loot boxes, loot crates, gambling, esports, the intersection of all of those disciplines, doctrines, and practices. And one of the most common questions I get in my own practice from especially independent developers all the way through mid-range studios and from AAA folks I've talked to is, are loot crates gambling? Are they legal? Are they not legal? Can I put things like slot machines in my game? What do I do with loot boxes?
Sure. Just kind of table set here. We'll start with the very basics of gambling law in a nutshell. This is an oversimplification, but basically there are three elements to gambling. There's a prize, which is usually the easiest to fulfill. There's something of value that you're getting. There's consideration, you're paying something to participate, and then there's chance, the element of chance that you don't have full control over whether or not you're going to get that. In the loot box scenario, it's kind of difficult and gray because certainly there's chance involved. You don't know what you're going to get in the loot box. Consideration, it depends. Sometimes you can have loot boxes where you're paying real money to get them. Sometimes it can be only through grind currency. This is kind of some of the terms that are used. And then there's this big question of whether or not what you're getting is a thing of value. It's kind of a little bit of table set. That's it.
And discuss.
What was the specific question?
Essentially, what are loot boxes? How are they used? So, like maybe, what are some examples of what people call loot boxes or loot crates? What kind of games are we talking about? What kind of platforms do we find them on?
Well, one thing, I have a colleague at my firm who used to be in-house for people who made straight-up gambling devices. And one of the questions you just see, well, how is the Battlefront loot box any different than a pack of baseball cards? And his answer is because the law says so. Because they've carved out, they've said, okay, sure, it looks like it, but baseball cards, that's not gambling. This other thing depends on what you can make the judge realize, or maybe the answer is, of course they are, regardless of what the judge thinks.
Well, I think it's important to realize, right, that most of these games are available in lots of jurisdictions, potentially the entire world, and not every jurisdiction looks at this the same way. Notably in Europe, you have the Netherlands and Belgium, which are taking more aggressive positions on this. You have a lot of places around the world where people have started looking at it, including here in the U.S. in some states, but it's not necessarily that there is a universal view. The concept of whether or not there is value being received is something that people look at in different ways, and there's also I think just a range of attitudes that people have in terms of what level of effect, does this also just sort of have on people? Even if it isn't gambling, you do have jurisdictions that are looking at the concept of whether or not, this makes users, perhaps develop tendencies, towards gambling outside of the game. So those are definitely things that are, evolving in a lot of areas. I don't know if anybody else can. I can't off the top of my head speak to, the few specific cases in the U.S. that have delved close to this area, but nobody has really, in the U.S. at least, to my knowledge, have we had a case that has very directly addressed the issue of loot box in video games, other than very, well, I'll say sort of almost casino simulation style games. We do have a little bit of cases in that area.
I do think it's also just worth pointing out, every state in this country, let alone other countries, every state has its own gambling laws. There really isn't a federal gambling law. So if you're okay in Illinois, you might not be okay in Indiana. It can really just depend a lot.
I think it's also worth, taking a step back and just reminding that like these loot box systems have been around for a really, really long time. It is, and without kind of issue for many years. I mean, in video games as well as outside of video games and trading cards, etc. I think it's really important to remember that this is a issue that kind of blew up only in the last couple of years because ultimately the systems and the people behind the systems, people's lives and livelihoods were starting to become affected by this. And when you have articles of people losing their life savings on loot boxes or spending $5,000, $6,000 in a year, or way more in some situations, like that's when, state regulators in general start to feel the need to step in. And certainly the player outcry makes a huge difference in terms of where legislative and regulatory resources get used. I would say in terms of, to your original question of like what advice would give independent developers, just one like solid takeaway is be very cognizant of third-party gray market activity. One of the things that really causes a in-game economy to A, get scrutinized, and B, just blow up in terms of scale is when you have the ability to trade and transfer items between players, because then it becomes very easy to have out-of-game transactions, and this gray market develops, and that in turn makes people way more likely to start to, do gambling and throw large sums of money on this sort of speculative market.
Is there anything from like a privacy compliance or a contractual perspective that game developers and game makers can add to their business practices to maybe insulate themselves while lawyers like us are trying to figure out where the kind of lines are and things like this?
From a privacy perspective, this is maybe a common sense thing, but dynamic odds based off of personal profiles, that's really risky. Because that's the kind of thing that could be discovered through a data subject access request. If you've been changing the odds or the drop rates based on a person's proclivities, that could get you in trouble.
There's certainly a lot of, I agree with that. I think there's also definitely, some other things that you can do that, a lot of publishers, for example, with their loot boxes, one, you're always going to get something, right? And this goes back a little bit to the point, Sam, you're making with respect to sort of, the baseball card, analogy, right? You buy a pack of baseball cards, you know that you are going to get, we'll call it 10 baseball cards, right? You may not know if those baseball cards are going to, include, Clayton Kershaw's or, whoever, some of the other 10 pitchers on the Los Angeles Dodgers are. So there could be an impact in terms of how desirable those cards are or not. But you know that you're getting 10 cards, right? Loot boxes, of course, you're typically going to be knowing you're getting something. What's varying is what you're getting. You can narrow the amount of things that are in the loot box, which I think makes it a little bit easier for people to sort of understand what they're getting. some companies will ensure that whatever you get out of the loot box is always going to be worth the minimum pricing of what you put in, right? So in a sense, you can only win, right? Worst case scenario, I'm getting a in-game piece of content that is something that costs, whatever, 100, virtual currency. That is something that I think does cut down on, you still have the element of you don't know which item you are getting, but you don't have that possibility of, hey, the publisher winds up with, a circumstance where you are never getting things that are the value of what you put in. Those are some of the, kind of common ways that people will, add a little bit of protection there.
You mentioned dynamic odds. Go back far enough, and I don't know how you would have done that in a casino environment, but I assume you could do it now with the club cards or membership cards that people will swipe before they sit down at a slot machine or a video poker machine. So has that issue come up in the casino environment? Have Nevada regulators weighed in on whether the casino can change the odds for a particular player?
I can't say because I don't study Nevada gambling stuff, but I do know that that is a heavily regulated industry, and odds must be posted, and that's a lot of. I can't say yet definitively yes or no, but if casinos were rigging games to make it easier or harder to win based on people's tendencies to pay, I think that there would be regulation.
I can speak to that,
Okay.
again, through talking with my coworker who has done this, and if it is in fact illegal to say, hey, let's give that guy a break, and rig it so, and I'm sure, the opposite, let's make it harder for that guy to win. But if you rig it so this guy wins and now he'll start spending more money, not only are you all going to jail, but the guy has to give back the money you gave him in the first place.
Well, once everybody describes this as rigging.
Well, yeah, I mean,
I accept that as a fair description, but if that's generally how it seems, then your suggestion that this is a very risky activity to engage in is a good one.
Well, something that I've heard of is games that implement these kind of mechanics. There have been instances of sending out review copies to popular streamers on YouTube and giving them different odds on getting things back to maybe solicit better feels, better feel goods on a game so that they might obtain a more favorable review. Would the panelists be in favor of a requirement either from the ESA or even a government requirement on the gambling regulation requiring games that implement those kind of mechanics to disclose odds right on the box?
I think what you're getting into almost speaks like sort of false advertising kind of thing. So I think you're going to hit some real problems there. If I think I'd be okay if you have here are the odds of, or at least the kind of things you can get. Maybe it doesn't have to be broken down every single the 350 pieces of loot in there, but I play Fire Emblem Heroes has the gotcha mechanic. It's all right, 3 different tiers of units you can summon, 3% chance for the really good ones, 50-something% chance for the middling ones, 30-something% chance for one of the bad ones, and I'm fine with that. I wish they were higher, but I understand at least what I'm getting statistically, so that's fine. I'd be
There's
totally
more transparency.
yeah, totally fine with. Okay, you have 2% chance of getting something from our super cool pile. That's good.
I ask because that's something that traditionally hasn't been present in the video game space, even though there have been so many instances of things like that. The likelihood of drops in MMORPGs, the likelihood of getting a particular weapon or a particular pet has never been thought of as gambling or loot boxes before. But I'm curious if we're moving in a direction where that kind of thing might have to be disclosed and kind of what the implications are for other games.
I would not be surprised.
well, I'll reiterate the disclaimer that I'm not speaking on behalf of EA or Ubisoft. My own opinion. I think just taking a step back, if you open a loot box and you are satisfied with your purchase, even if you didn't get the thing you want, maybe as Nate said, you get something that's at least the value of the time you put in or the money that you spent. Those people aren't going to be the ones who complain to a regulator or who file a lawsuit. I think it's in everybody's best interest to create a loot box system that people feel good about using. And whether that's being transparent or whether it's just actually building a system that gives out good stuff at every stage. I think there's a lot of ways to do it right. There are almost as many ways to do it wrong. And I think it's really about managing consumer expectations.
Any questions in the room on loot boxes?
Yeah, well, one question that raises is sort of the relative value of the things that you receive in the loot box. If I'm diehard playing this one character, I may want to get a skin or even an animation for a character that for somebody else may be trash. So it's tricky to try to come up with, okay, are you getting the value out of it? Well, that depends on the individual. I guess in the aggregate, you could do polling data. I don't know how you decide that, unless you're selling these items independently. If it's all being delivered through loot crates, how do you decide whether or not you're
third-party
delivering?
marketplaces that like value on them. So just as one point of reference, there was a lawsuit over this about a year ago against Big Fish, and it was from a consumer who had spent thousands and thousands of dollars buying in-game items, and I don't remember if he was trying to make it a class action, probably, but the case was actually dismissed because the judge, and his argument was, look, he has a gambling problem, he spent tens of thousands of dollars, and this is gambling, he wants his money back because it was illegal, odds were disclosed, and this and that. And the judge dismissed the case and said it wasn't gambling. And when you read what it really turns on, what it really came down to, while it was able to be decided on a motion to dismiss, was because the in-game items that he had complained of were not individually sellable. There's no way to sell these items. And the plaintiff said, well, there's a third-party auction house, and they provided screenshots and links, and they go, here's a third-party auction house where people are selling their accounts. So it doesn't matter if it's third party, there's still a market for all this. And the judge said, well, no, because you can only sell the entire account. You cannot individually sell something and get out of the loot box. And because you can only transfer your entire account to another player, the value, and I'm not sure he's correct about this next part, he said the value of the account is not tied to the value of any individual item in the loot box, because you can only sell the account as a whole. So it's not gambling. I thought it was decent reasoning. I'm not sure it's correct to say that the value of an account is not tied to the value of the items it has, but that was his reasoning.
One thing. Oh, go ahead.
I was going to say, yeah. I mean, I think one of getting back to one of your questions, Ross, about what are things that that developers should think about. Having your T's and C's, your terms and conditions, point out whether or not something is transferable is good, right? When some of the times that people have had some issues, it has been, it's that transfer of things that are in the accounts and setting it up so that may not be technically possible, or at least where that is against your terms and conditions, does help provide you some protection sort of against that. Because, yes, one of the very traditional points that people have always made with respect to loot boxes is, this isn't something that has real world currency. And, there isn't a means to cash it out of the games. And generally speaking, and by the way, while there has been a fair amount of uproar in the last year, from users, et cetera, it is, worth noting that, well, I said before, there are a lot of places that are looking at loot boxes. There's even a few places that have, taken a little bit of action. There are definitely also places that have gone in the opposite direction. Somebody correct me if I'm wrong, I believe it was the Gambling Authority in the UK came out and said this is not subject to our jurisdiction. So, you do have, this is not like some uniform view that people have, nor is it, uniform that people think that there's, any sort of problem. And I think a lot of what people are trying to get at is part of it is, you want your user expectations to be met, right? If users are viewing this as, hey, this is part of the fun, right? Part of the fun is I'm getting something that I'm not sure what I'm, getting, and that in some of the same ways that some of the things that might make a battle royale game fun is the fact that those crates are coming out randomly, right? And that adds an element of chance in the game that all the users need to deal with. No different than a bad bounce of the football, after somebody punts. You want it to be something that your users are enjoying, I think. But yeah, keeping it in the game, I think, is another good way to do that.
I kind of want to pivot slightly to, I guess, maybe semi-related issue. There was a case locally not too long ago dealing with free plays, free lives in Candy Crush. And I don't play Candy Crush, but apparently if you get people to click on something on Facebook or somehow you can get your friends to give you free extra lives. And then Candy Crush wasn't giving those out just to some people over a certain period of time. Again, I don't remember the details. And so they sued to say, hey, in breach of contract, you owe me those lives. And the judge said, well, we can act, no, because you're selling these extra lives otherwise, it's a, say $5 for $1 or whatever it is. So clearly, these have a, if that's right, base price 20 cents. That's actual thing you've promised to give them with real value, and you haven't done it. All right, let's go ahead with this lawsuit, which I thought was very interesting, and I think it's probably the right result too. But just for the developers, be really careful what kind of in-game currency you're giving out, especially if you're selling it otherwise, because I think this is a decently well-reasoned, proper decision.
I think that actually offers a great segue for another topic that we discussed during the break that I kind of want to transition into, and that's in keeping your fan base happy. How do you kind of walk the lines between marketing, branding, engaging with your audience, and then also maintaining your IP protections and legal protections? And specifically something that is, I know for everyone on the panel, has been a constant devil on our shoulder is that the fair use question, fan games, DLC, user-created content. Where's that happy medium between fan games that are homages or spiritual successors, and where are the ones that are directly knocking off your IP that you need to drop the boot on?
Sure, I guess I spoke a little bit about that in my talk, and it's a tough line because you can try to draw the line of, well, anything commercial, right? Anything, you can use our content. You can make if you're a fan, you want to draw a picture of one of our characters, that's fine, and you should absolutely let fans do that. You should absolutely let fans make things and let fans make fan art. So you want to draw the line sometimes at commercial, but the problem with that is that a lot of fan art is commercial because maybe they have a YouTube channel, and their livelihood they're like PewDiePie or something. Their livelihood is their YouTube channel, as so many people are, and then they're showing off their fan-made art on your YouTube channel, which is great. It's great for you. It's great for them. Everyone wins. But now it's commercial. Right, so your line isn't anything you're making money off of. So then, where does that line become? I don't really have the answer. It's a judgment call at the end of the day. But
and one thing that we do. As referenced many times, and not speaking specifically, for Hi-Rez Studios here, but one thing we do, I think, is consistent with what some others do as well, which is, when you talk about, the commercialization of streaming, et cetera. We have a license that is open to the community that they can stream the game, and we permit them to even have take subscriptions, etc., from Twitch and similar platforms, so long as their content is free to the public. So that while we recognize that permits them a way to make their livelihood, it's still allowing the other users to get to the benefit of that fan, created content that they're doing. So, for us, I think that's sort of a nice happy medium, and certainly there are others that, that do that, but that's one approach.
Now, I work with indie developers, so I don't have the one client. There's not one policy. On the one hand, it's really, what does the individual client want? And I think really probably, if I had to put a name I boil it down to, is this offensive or upsetting or something like that? Streamers are great. If there's fan art, that's probably pretty cool. But I've had to do a DMCA takedown. Well, that's just a ripoff. That's not even an homage. That's just straight up stealing my client's game. And there's obviously a lot of range in between. But I think it really, for me at least, boils down to, are you okay with this? And I'm not there to necessarily be the marketing guy. I understand at least some of the basic concepts, but really, are you okay with this? If so, great. If not, let's figure out what you want to do about it.
So I actually have a follow-up question for you on that about Hi-Rez
Sure.
games. and if you want to speak to them individually, it's fine. But what about things like YouTube Red, YouTube Twitch channels that sometimes require a subscription? Would you not allow that because it's no longer free to the public, so now you're forced against that? Or is it still just is that just enough of a gray area where you don't give it away?
Yeah, so I mean, I don't want to get too deep into sort of like specific, circumstances. I would agree with some people that, there's a variety of reasons why you may make a decision in terms of why, you might take something down. But yes, as a general matter, with respect to our general free license, we take the tack of it needs to be something that is available to users for free. So the specific circumstance you're talking about being a little bit different.
Moving forward with streaming, is there, and that's another, that's a whole other entity getting into streaming and live streaming and how that affects branding. Because it sounds like when I'm talking with my clients who tend to be independent game developers, the questions I actually ask them is this helping your brand or hurting your brand? And is this affecting your bottom line of commerce? And that's kind of the angle we take it from, is this helping or hurting? Is there, and tell me in your practice or anyone else on the panel, is there an advantage to being proactive in seeking licenses or collaborations with people who might be making infringing works or parallel works or sequels, homages, acts, mods, or whatever they want to call them? Is there an advantage to being proactive to work with these people, or is it kind of an ignored until it's a problem and then go after them aggressively?
I mean, that's really kind of, when you see the kind of question.
Sure.
I think, again, it'll vary depending on the client and what the use is. I mean, there is really sort of a stigma, I get, against sending that cease and desist letter, because we've seen so many ridiculous, irrational, over-the-top C&D letters, and you don't want necessarily to be that guy. Oh, and then the infringer comes by. Look at this terrible thing I got. I was just doing this innocent little thing. Look how bad they are. And that's not good, obviously. On the other hand, sometimes it needs to happen. And sometimes it's not every time the infringer has crocodile tears on the internet. Sometimes it just goes away at that point. But that's something to kind of be aware of, and maybe what the person doing is pretty cool, and you want to maybe not necessarily let it go, but you do partner up, you do license, or just say, hey, it's fine you're doing that, just be aware and don't cross XYZ lines. I mean, like I said, it depends, but I think there are definitely different paths you can take depending on what's going on.
Do we have any questions in the room for the panelists?
So, when you're making these decisions, and I think there's a frequent note that it can change from developer to developer. Do you see many changes with the same developer from one game to another? So perhaps there's one IP that they want to have more protection over, and others they may not care about, but they want a consistency to the communications. Or alternatively, some reason where I could see a strong benefit in having different policies would be if you have some games that are geared towards younger children and other games that are geared towards older adults. Do you recommend a different approach?
Sure. So I can't speak necessarily to IP issues, but yeah, I think you're absolutely right. That the risk calculus is happening on both sides. So there's the person making the fan work has a risk calculus. The person who owns the IP has a risk calculus. And you're absolutely right that the target market of the IP absolutely has an impact on the risk calculus. If you're talking about a kid's game, if you're talking about a game that has other third-party licensed stuff. If you're talking about making a Star Wars fan game, it's not necessarily the publisher you have to worry about. It's Lucasfilm, and you are often at the beck and call of the other IP holders that might want you to enforce. So yeah, it definitely. Again, it's like this big. There's no one size fits all, and it's a very case by case. Talk to a lawyer, and the factors that you point out are absolutely part of it.
I would just say one thing that just occurred to me. if you are a developer, do not send your own cease and desist letter. Please no.
I think we could just have a blanket statement. If you're a developer, don't do things your lawyer should be doing.
And don't send one without telling your lawyer, putting your lawyer's letterhead, putting their lawyer's.
Oh, that's never happened to me,
Somebody
but I'm gonna have nightmares now. Thanks a lot.
It's happened
Thanks a lot.
to me twice.
Oh, I'm so sorry.
Oh, also, not semi-related, this is another duh thing, but like, if you're making a game that like disparages the brand that you're, like, if you're talking about like Pokemon and then there's like pornographic stuff in it, obviously. Like, so when you're talking about how the risk calculus to the brand, they're thinking about the damage to the brand as well that could exist if this was not. That's common sense.
One of the other questions that we've had on the internet is one that I've heard a lot here in Chicago is the subject of video game unionization, industry unionization, both from the developer side and the studio side. It's a topic that's been kind of hotly contested lately. People are weighing pros and cons and trying to weigh out kind of industry goals and where we all want to get as an industry. Does anyone have any burning opinions or thoughts just on the subject generally, specifically, or do we all play Turtle and not answer? Like, okay. I was worried about that.
Well, I think
I'll keep talking.
I would imagine the in-house counsel is probably a very sensitive question for you guys.
Yeah, I can't say it.
I mean, as in most things, I totally see both sides of this. I mean, you hear all these horror stories about people being forced to work excessive hours and the burnout and all this. So I think some kind of unionization is coming, whether anyone wants it to or not, just based on how awful this is. And I have no problem with unions per se. I do wonder something about the logistics of this, because games are so cyclical. Like, okay, we finished a project, and this is a complaint you often hear. We finished a project, now everyone's out of a job because we're done. And no one's going to be doing this again for another 6 months when the studio picks up again. Which is a real thing and a legitimate concern on the employer end. And I don't know the best way to kind of deal with that. I don't do a whole lot with unions in general, so maybe there's an obvious analog to some other industry. But I worry about how we're going to deal with some of that.
That's true, and no one on our panel is an employment lawyer per se, so that question might be a little bit outside of our own bailiwick. But from a transactional perspective and also just a general counsel perspective, maybe another way to come at this issue might be for creative people, for developers, for designers, for programmers, for artists, sound engineers, going into an interview at a studio. Are there some best practices for them that you've seen that have worked well in your own practices that have led to better worker satisfaction, better contracts? Is there a way for them to redline offers, to better negotiate for themselves from an in-house or business perspective? Is there something you like to see from applicants that leads to more favorable results in workplace bargaining, I suppose? Oh, God, so quiet.
I can speak to it a little bit.
Sure.
My experience has been, in terms of redlining and negotiating your own contract, it very much depends on what level of rock star you are coming in, and and because ultimately the people who will be making the decision of, oh, does this person get vacation hours or X or Y, depends on the business and how bad they want you.
Sure.
So I've seen some times where we've bent over backwards to get somebody on board and changed a lot of things, and then other times we've just shut people down.
Sure. Quality of talent, bargaining position, all
Yeah.
those big factors in hires.
So I just want to say for the people listening, as you don't have a microphone, the person pointed out that the more of a rock star you are, the more likely you're going to be able to negotiate this employment contract, and that's absolutely true. If you're an entry level position and you start redlining your employment contract, you may never hear back from a video game company. But if you are lateraling over from another firm, just another firm speaking, lawyer speak now, from another studio, and you are the more of a rock star you are going to be able to push back, you are going to be able to negotiate. The other thing I will throw out there is that to the extent you are working 60-hour weeks and this and that and no breaks, you have significant, especially in California where I practice wage and hour claims. And maybe if you have been working this way at your studio and this is their general practice, and you're unhappy, you want to leave, I mean, you may want to speak to a plaintiff's employment lawyer about making a claim, and maybe if enough of these claims are made, maybe companies will start changing their practice to avoid them.
I want to echo that because one of the things you see a lot in contracts for these game studios, it always says, "Oh, you're an independent contractor." That is probably untrue in like 90% or more of the cases.
Especially in California, there's almost no independent contractors in California. In fact, California courts have recently said if your contract says you are work for hire language now means you're an employee. So when we sign independent contractor agreements in California, we have to be very careful not to say work for hire, which is pretty much the standard everywhere else, and we just say, well, the IP and everything is assigned. It becomes very, very difficult to have there be anything except employees in California.
In Illinois, at least for payment of wages, it is nearly impossible to not be an employee. I mean, you have to be like doing an independently established business, doing work outside the company's general business, and like no direction from the company. Otherwise, you're an employee and you have to follow these regulations.
Right. So I think the point here is simply can be summarized as, just because you think you're an independent contractor and employment laws may not apply to you, that may not be the case. Talk to a lawyer. You very well could be an actual employee.
So I will weigh in a tiny bit. I think it probably is a little bit of an overstatement to say that it's not possible to be independent contractors, and I think that I agree that there certainly are states, California notably is one where the courts have tried to be very flexible in trying to think through form over substance distinctions of whether or not somebody is an employee as opposed to truly an independent contractor. But there definitely are, I think, lots and lots of people in the video game industry that are independent contractors. Not that it's the end all be all, but they work with a number of different companies, and they meet all the various requirements to be an independent contractor. A lot of them certainly are highly skilled on top of it, and so they're in demand and they can do better by working for multiple companies. It certainly is possible to do both, and I do think it's also probably good to note that generally, not just in the video game space, but in the U.S. economy as a whole, right? We are moving in a direction of
The gig economy.
The gig economy, right? I mean, there's a lot of people who are sort of working, whether they're these side jobs or whatever, and so there's a little bit of these two competing, I think, things happening right now in our economy as a whole, where courts are trying to weed out some of these form over substance problems with people who truly are employees, but at the same time, there is a competing move a little bit towards providing freedom for people to do a variety of things and do it on their own terms, do it at the hours they want to do it, the amount that they want to do it. And of course, just different states have different approaches as well.
I'll just try and add to this. Just, the industry is constantly changing. The way in which games are produced is constantly changing. The expectations of fans are constantly changing. I just saw, I don't know if you guys saw it, there were the fans of, I think it was Warframe, put out a thing saying we don't want our developers to be crunching. It's just really interesting at how there are constantly these sea changes, and I think game developers are trying to be very nimble and innovative in how games get made and how they are consumed and how they are presented. It's a very competitive market, and there's a lot of room for a lot of different approaches.
Definitely, and with that, the game industry is changing all the time and constantly innovating and evolving, as you say. As practitioners, I imagine, like me, that makes your job very difficult, trying to stay abreast of all the new developments that are going on. But in the last year, being as transformative as it has been, what's something that you wish would happen in the industry that either would be academically fascinating or practically just make your life a lot easier? Is there a law that could be passed? Is there a decision that could be reached, or some kind of new business practice that could be implemented that would, in your estimation, shake things up or kind of change the industry for the better?
Okay, you kind of touched on this earlier, Stephen, but if the trademark office would stop calling slot machines the same as video games, I would be elated
Right, yeah.
beyond belief.
I'm actually appealing one of these to the trademark trial appeal board right now. It is though over a board tabletop game. They're saying that the name there's another trademark application on record for a similar name for slot machines, and they said no,
For a board game?
for the board game, yes. And because the trademark office says, well, board games often involve dice and cards, and so really they're the same thing as slot machines. And we're appealing this to the T-Tab right
Thank
now.
you.
And my goal here, I actually hope that the examiner does not back down, because I want to make law on this, and I want to set the record that gambling machines are not related to tabletop games or video games.
I need to, let me know what case that is. I want to follow that
Right.
very closely, because
Right.
that's even more egregious than what I had to deal with.
Right. So
Wow.
So that is annoying. Interesting. The case law. I talked a little bit about this in my talk, but the whole copyright issue and what does copyright apply to as far as game mechanics is an interesting issue that needs to be addressed in more circuits. There's a lot of courts. So the summary is that for about 20 years, copyright law never covered game mechanics, and copyright law does not cover game mechanics. There's been several cases in the past several years that pushed hard against that and said that, well, if you copy all of someone's game mechanics, now you have copyright infringement. If you copy enough game mechanics. And it's a gray area, and it's really unclear. You know, I'd hesitate now to say there's a hard and fast rule that you cannot copyright game mechanics. It's yes, but is now the answer. It's a gray area. You will still sue people. You can still win. I think there needs to be a little bit more certainty in that area of the law. And I don't think you should be able to copyright game mechanics at all. I think the cases saying that you can are wrongly decided.
Because the precedent for so many years was that was the realm of patent ideas and
Right,
mechanics
yes.
no longer patent. And now, with the element of copyright being added to it, I personally think that that's kind of just a muddying of the waters. It's just causing a blurring that's leading to more ambiguity and problems and solutions.
Absolutely. If you want to protect your game mechanics, if you think they're novel and ideal and great, then the law allows that, and that's amazing. Go file a patent.
I wouldn't agree with that characterization, though, that the change occurred in that way. If you look at the older cases involving copyright litigation, games in the 80s, for example, you find that courts were protecting things and finding infringement, where implicitly they were protecting things that are fairly described as game mechanics. But the courts didn't talk about the issue. In other words, there was no explicit discussion of what's part of the game mechanics and what's part of the artwork and the music and all the other elements that are layered on top of the mechanics. It was all just lumped together. And so I think you can find multiple cases where that line is getting blurred between the mechanics and the artwork and other features of the game, and the court simply isn't talking about it. So the takeaway from those older cases was, if it looks like the other game, there's a good chance it's infringement, even if the reason why it looks like the other game is because it's following the same sort of gameplay design. So the older cases, I think, lent support to the idea that you could protect game mechanics. You could never say that. I mean, because the black letter rule, you're right, was always that you couldn't protect them. So if you go look in Nimmer on copyright, it would say you can't protect game mechanics. But when you look at what happened with these cases, you go, well, as long as you don't say that's what you're doing, as long as you say, well, this one looks like that one, then you have a decent chance of prevailing. And it's only the recent cases where they actually will say things explicitly about game mechanics. And in the recent cases, like the Tetris one, for example, the court will say, well, of course you can't protect game mechanics. But then it seems to do precisely that.
We're protecting game mechanics.
well, that's the outcome of the case. And now we have a lot more cases on it, and I agree it's a little more confusing. But while I think it's entirely true that in some cases it may be hard to figure out exactly where that line is between the mechanics and then the artwork that's layered on top of it, I think there are plenty of examples where courts do a very poor job of even trying to think through the issue. If we switch to a system where patents are the option, well, post-Alice, what's the probability of protecting your game mechanic? I don't know the answer to that. It's not a horrible question.
I think patent examiners, patent attorneys have gotten very good now at drafting patents around Alice. There's been a lot more it's been 4 or 5 years now since Alice was decided, and for the non-lawyers, Alice was a Supreme Court case that said that you can no longer get a patent for something that has existed for a long time, but now you're just adding to the end of it, comma, but with computers. So for example, in the Alice case, someone had tried to patent escrow or escrow, how do you pronounce it? Escrow, but with computers, online. And the Supreme Court said, no, this may be a new concept in that no one has done this online before, but you can no longer have patents for just something that's been around, but now you're just doing it on software online. And for, created a few years there where basically all software patents were being denied, citing Alice saying, no, this is just software. But I think patent drafters have learned how to draft around Alice and tie it to hardware, and I think game mechanics, my firm, we have a patent lawyer that works for us and does nothing but patents, and we're able to get around Alice. The hard part is for most game designers is they're never going to be able to rely on patents because they're too expensive, and unless you're Ubisoft or Activision, you don't have a budget for one patent for $25,000-$30,000, and if you did have it, you're better off spending that on developers. You're better off spending that money elsewhere.
Yeah.
So it does this rule, if we did not allow copyright over game mechanics and said you must rely on patents, it is intrinsically favorable for the big guys and not favorable for the small guys, who will then not get protection. Then the big guy comes over and steals their game mechanics and basically their game, which happens. So yeah.
Yeah, I'll add to that. Again, not speaking on this. I don't do IP, so this is even more just my personal opinion. But I would also say that to your point that like game mechanics are not expressive. I would put a little bit of pressure on that, because I think that there's a lot of ways in which the impact of a game mechanic can be the point of the game. So there's this great video online that Extra Credits did about mechanics as a metaphor. And they talk about this game, I can't remember, I think the game is just called Loneliness. And you're just a little square, and as you move your square around the screen, all the other squares run away from you.
Oh.
And it's just like, it's a very simple thing, and then at the very end there's one other square and the two of them like meet, and it's like a love story told with just squares, and the entire the only reason that it is effective as a piece of expressive media is because it's interactive, and it's because you control the square as it runs away tries to make a friend. And I hesitate to say that mechanic ought to be patented, or that it is not expressive and therefore it needs to be a patent. I think that the waters are muddy, particularly in games which we all know are art, and I think that it's not so clear.
The board game, you mentioned board games earlier, so on the board game side of things, my impression, and maybe at some point I'll try to turn this into a research project, but my impression is that for a very long time, the publishers of board games, it's not video games, but board games relied on some informal norms to deal with this. So they're not filing patents over this novel game mechanic. Instead, the publishers recognize when some mechanic is unique to a particular game designer, and perhaps for some period of time will recognize that's sort of that person's game mechanic. And at some point it starts to be copied, sort of, and at some point it just sort of becomes everybody's. But at least for a period of time, you get an informal, customary, patent-like protection. Now, things like Kickstarter and the ability to publish your games on your own through GameCraft or something like that may put pressure on that feature of the game industry. But in the video game industry, is there any similar norm operating?
There's definitely market forces. I mean, there's definitely, the perception that, this is just a ripoff of some other existing game, and, people will call you out on it if you are just kind of informally cloning another mechanic. But yeah, it's really tough, because there's certainly I know it when I see it, game cloning issue, but then there's like, do you really want to get the lawyers involved in something like that?
Well, what if someone took I think your what you were saying earlier about a game mechanic potentially being expressive is really interesting and fascinating. I worry, because what if the first person to do Battle Royale mode was then able to argue that, look, this is expressive, like the concept about, we were the first people, I don't know, it was H1Z1 to do Battle Royale, namely them. They said, look, this was a brand new mechanic, this is something we had done, no one else had done it before, and this is expressive, and here's why it's expressive. I'm sure if you got a creative lawyer to sit down and think about it for a week, they could draft something amazing about how expressive it is. And now they're able to shut down Fortnite and PUBG. Like, that worries me.
Yeah, totally.
Yeah, I think on a policy matter, I don't want game mechanics locked down behind a 95-year copyright wall.
Yeah, exactly.
Or
Or
that's my, I agree with you also that, this is the realm of patents, if anything. And maybe it's just nothing. Maybe we, as another option, maybe it's just nothing you can protect.
Yeah.
But I really don't want to live in a world where, we're going to lock some cool new game mechanic behind a 95-year copyright restriction.
Well, and consumers who complain about this, I wonder how far they would take this, because when you have a genre-breaking game come out, and this is really the first one that people associate with the genre, first-person shooter or whatever, I don't want there to only be one of those games. I want other people to compete and design other games with different themes, different artwork, different music, different characters that build on that basic game mechanic. It's the same with any other product. We don't want only one manufacturer of a hammer, so even if we give a patent to the first hammer, at some point we will want some people to make the hammers. So when the genre-breaking game comes out, and the second game comes out, people might complain about, that's just a rip-off, but well, that's kind of what we want. So
Yeah.
we have to have a balance, and the balance probably here is off because it's not clear how you're supposed to protect the mechanics, whether you go the patent route or the copyright route. If you have to go the patent route, it's extraordinarily expensive. You're simply not going to do it in some industries. I suspect that a lot of the patents in this area are probably junk patents, where you get some designer who really isn't that familiar with the industry, but is very excited about the thing they've come up with, maybe more in the board game context. And they find the patent lawyer to file a patent, and the examiners are probably not very good at searching the prior art in this area. And so you end up with a bunch of patents on a bunch of things that nobody actually cares about. I would guess a higher percentage of the patents in this area are likely in that category. For video games, I don't know if that would hold, but maybe it does.
Well, it's hard. Oh, sorry. Go ahead.
But
You were going to more directly respond. I was throwing one slightly different concept.
well, I brought up the expressiveness of game partially to be a contrarian, but also just because I think that neither copyright nor patent really kind of addresses the policy issue that is kind of that, we don't want somebody to own, even in the example I gave of the loneliness, we don't want someone to own the concept of a loneliness mechanic, and it's a really interesting, delicate policy balancing act.
Well, I think that example shows that the mechanic can definitely support the other expressive content. Now, if that very simple game wasn't titled Loneliness, I don't think it would have the same effect. If somebody simply published, move the square around and gave it some kind of name like that, move the square, and you just see the other squares move around, it might not have any effect on you. But the fact that it's called Loneliness and sort of evokes these thoughts of what it's like to be repellent to everybody else, that's what gives the game mechanic some effect that's particularly noteworthy. And so the game mechanic, I think, can work with the other elements of expression, in this case just a title. Is there anything else? Is there any background, any music or anything? Is it just the title?
You can certainly protect the music.
Right.
Because the way that you describe it, it sounds to me like that's a heavy narrative. Like I'm caught up in the story, not so much the aesthetic of it or the mechanic of it.
Sure.
So depending on the art style, the music, other expressive elements, I certainly think there's a story there, but I don't know that patent is the way to protect that. What it's jogging for me is the cutscene in Pac-Man. I'm thinking which is patentable, no longer. But I think of where is that blurring between copyrightable narrative or expressive elements, and then what's an actual play mechanic that actually involves how you interact with something. And with the games we're talking about, there's so much blurring. I mean, Angry Birds wouldn't be Angry Birds without the pull and shoot.
Right.
And that is part of the story, is the slingshot. So
Well,
I don't have an answer.
There are certainly the hard cases. So you think about Where's Waldo book. You can think of that as a game. All you need to do is rewrite the instructions to sort of describe it as a game. It becomes a game. Find Where's Waldo, or find Waldo in the picture. And I wouldn't want to say that's all game mechanics, such that you can reproduce the image of Waldo hidden among all these other people and say, oh, well, that's not protectable, absent a patent, because the artwork and the mechanic blur together. A sort of merger doctrine, where the mechanic and the expression merge, and so now you get to copy it. So there are going to be some hard cases where you'd say drawing the line isn't going to be very clear. But I think the courts have traditionally emphasized too much of the visuals and just treated video games like they would film and say, well, this looks like that.
Right.
That's infringing. So you have the Pac-Man case and Casey Munchkin. Those two games don't rely on the same map. So there are general similarities between those two games. But the court made it sound like you can protect the map, even though the map starts to sound like a play field, like a baseball diamond. You can't own a baseball game through copyright. Well, I guess if the video game came first, you could. If baseball started as a video game, maybe somebody could own it as a game. But ordinarily, I think we'd say that play field is surely tied up with game mechanics. So the Pac-Man map, what do we do with that? Maybe that's not protected. Little characters would be, the cutscenes would be, the music would be, the very simple story that's attached to the cutscenes, that would be. But the courts perhaps were overly generous at the time, when maybe it helped the video game industry to be overly generous, but I'm not sure that you need to be as overprotective now as perhaps it helped to be in the 80s.
So we've got about 15 minutes left on this panel. I'd like to open it up to the room and also to Twitter. Is there any questions that anyone here has that they'd like to ask the panelists about anything we've talked about or something completely random we haven't touched on at all? I know there's one.
So talking about protection of gameplay mechanics, and there seems to be a general consensus that overprotection of gameplay mechanics would be bad, would be stifling for innovation in the industry. To the counter that, to the extent that intellectual property protection is meant to incentivize the creators to profit and succeed based on their work, is there a need to? I mean, if there is no protection for gameplay mechanics, is there a disincentive for creators to innovate? Like, do I want to invest in creating this great system, creating the game of baseball or something like that, if someone's just going to go rip it off?
So I'll echo the question for the microphone. Is there a disincentive to creating new and exciting things if it's so hard to protect intellectual property or new mechanics or new expression? Why bother?
Can I start?
Yeah,
do you want to start? I'll be
no.
provocative.
No, I was going to be first.
Oh, you want to be provocative? All right, well,
Because I've taken up the role as like the semi-pro IP person on the panel. So I'm going to say that the example of, the App Store and mobile is just so awash with support. And that was in your slides. I mean, it's just there are definitely attorneys out there who are really trying to find new tools to combat game cloning, because it is a really huge disincentive for mobile developers to enter the space at all, because of how easy it is to clone the game and it is whack-a-mole. So there is definitely a problem there.
Well, I think in the space of, I agree, mobile is definitely a bigger issue. It's just easier to do it. I think that one of the particular issues also when you talk about mobile is just the prevalence of a lot of the offenders being in jurisdictions that are a little bit harder to reach into and avail yourselves of legal remedies. When you talk about large AAA scale games, the really truly bad offender, if you will, it's really expensive to make a really big AAA game, right? So it's a lot harder. It defeats some of the purpose, right? Like if I just want to really cheaply, quickly rip off somebody else's thing, well, if it's still going to cost me a lot of money to go rip off your thing, that would sort of still be a problem. I was going to weigh in actually a little bit before when you were talking about sort of the price one would pay with consumers who may backlash to a game looking too much like another game, being similar. That is a real cost, but I was going to throw in also, there's also just the fact that if you're not offering something new, who's going to go buy it, right? Like if you're not differentiating yourself from another game that is already very popular, why are people going to move over from that game to your game? It can make a difference there, I suppose, if you're free to play or a premium price game, right? You may have more opportunities to undercut people on pricing or something like that. But for the most part, I do think that most consumers, right? I mean, they've played that game, right? And now they want to play something new. So you better probably be offering something new to really get those consumers anyway.
Well, I was initially going to give the opposite answer. Now, I'm open to the possibility that I'm wrong, but my intuition is that the cost to come up with a clever new game mechanic, which is a little bit different than the entire game that might be subject to the cloning, but when I come up with that clever new game mechanic, I would guess that the cost of doing that is relatively low, comparable, say, to the cost of figuring out whether I can come up with a new chemical compound to cure some condition, where the research costs can be enormous. So I would predict or expect that we probably don't see much of an incentive effect, especially since most clever new game mechanics won't be patented anyway. And I would guess that we would continue to get the same level of innovation in terms of clever game mechanics without the patent system. So the patent system might actually create a problem by just stifling some innovation if people get worried that they're bumping up against the occasional patents out there. But I just don't see the costs that go into it as being as significant as, say, in the pharmaceutical category, where cost to develop is enormous, cost to copy is extremely low. I just don't see that phenomenon happening here.
I agree. I think you touched on a really interesting side issue, which is that the innovation can be stifled just by the fear of people with patents coming after you. The existence of the patent system can sometimes stifle innovation because you say, I don't want to make this. I don't just like, what if I end up infringing someone's patent and then end up on the wrong side of a patent troll? I think it's very unfortunate. I think people should just not feel that way, but people do feel that way, and that's quite unfortunate.
Also, if we do want to rely more on patents as a way to protect game mechanics, if we do think that we need it as an incentive, I would guess we need to have some way to have better review of these patents in the patent office. I don't know if they're consistently assigned to the same department.
There is a video game department.
There is now?
There at least for a few years. Well, I know I just had lunch last week with an examiner that just does video games.
Okay.
And
Okay,
I don't
that's
know if he's like
interesting.
a
I did not
video
know
game
that.
department, but he just does video games.
Okay.
All he does is video games. And I was pleasantly surprised. I should have asked him like how long they've had this. I don't know, but I know he was assigned to only video games. I thought it was very interesting.
And does he see? It is he, right?
Yes.
Okay. So does he see the field of prior art is going beyond what he can find in the patent system? Because that's one way.
I wish I would have asked him more questions about it. I think we talked about our dogs. So.
One of the most notorious examples is that Sanity System patent, the Nintendo patent. And
Eternal Darkness, yeah.
yeah, and this is a patent where they take the basic game mechanic of having your sanity change during the course of the game. It can change as a result of seeing gruesome things or being exposed to things in the game that might make somebody tend to go insane. If you start to go insane, certain effects will happen on the screen. You'll hear voices or see spiders go across the screen or something like that. Well, that's fine and great to incorporate into a video game, but it had been used in pen and paper role-playing games for many, many, many years prior to being put into a video game. And none of that prior art shows up in the patent.
Yeah.
I assume the examiner had never heard of Call of Cthulhu or any of the other games.
And now they run into an Alice issue now.
Yeah, well, okay, so you brought actually a point that I really want to flesh out, which is that patents and copyrights differ in a really important way, which is that patents must be like original novel. And if we protect game mechanics through patents, then you have to do like prior art searches before, if you're really trying to be conservative. Whereas in the copyright, part of it proving infringement is showing that you have some, copying, exactly, knowledge of the other work. And that's, again, I don't profess to, be an IP expert but to me, I think copyright makes a little bit more sense for a mechanic like the sanity meter, because if I was creating another game and I had never played Eternal Darkness, I shouldn't be, as a developer, forced to do searches of every other game that came before me to see if they might have had a sanity meter in their game.
So you prefer the patent approach or the copyright?
No, because the copyright approach, you wouldn't be held responsible if you had never, if there was no evidence of copying.
If you have access.
Yeah, so copyright, even if they can't prove actual copying, as the professor was saying, if you have access to it,
Sure.
then that's enough to assume copying.
Well, it might depend on the level of similarity. So the court might say, is the level of similarity enough given access?
Right, if it's so similar,
becomes a
they
real
can
problem.
assume that you had access. But again, that's...
But it becomes a real problem to where you might actually worry I'd better go searching because somebody could accuse me of having copied and it would be hard to show I didn't. Because I don't even know what's out there.
Yeah, copywriting is worse because the problem with copywriting is a patent is everything is protected by copyright. You don't need to register it, and if you register, it's a $55 and in fact now $35 filing fee. Whereas a patent, you're at least met with the barrier of it's going to cost $20,000 to $50,000, and so very few things are patented. Whereas if it was copyrighted, everything would be copyrighted, and that could stifle things maybe.
There's a case from the Seventh Circuit across the street, and it involved the copyrightability, well, whether or not the Sherlock Holmes characters were still under copyright, and whether or not any of the stories were in the public domain. Now, while the court found that several of the stories were in the public domain, it described the potential for copyright infringement in terms that I thought were overly broad. So it said certain stories were still protected, and that would mean somebody, and I hope I'm getting this example right, but it was something like, because the story where Dr. Watson is referenced as getting married, you couldn't take those public domain stories, build on those, and have Dr. Watson get married. Now that seemed wildly overbroad to me. You're now protecting just the idea of Dr. Watson getting married. That can't be protected, could it? But the court made it sound like it could. Now, fast forward to when, say, Superman goes into the public domain, and I want to make a new Superman story or a video game or whatever. In theory, I have access to thousands and thousands of comic books and TV shows and movies where any of these very general things could have happened. So if I decide, I'd like Superman to become president, oh wait, I wonder if they ever did that. There are thousands of Superman stories out there. I don't have copies of them, but I will be deemed to have had access to all of them. And if we actually conceive of what might be an infringing derivative work as broadly as some of that dicta in the Seventh Circuit case, I would be very worried if I'm going to take a character who has this sprawling legacy that's very hard to track down, because I might be found infringing of something. I don't even want to look at it, but if I don't, I may run up against, Superman goes back in time. Well, they probably did that. Superman fights dinosaurs. That's probably there. Becomes president, gets married.
Probably safe and fair.
If he flies around the world.
So
I'm going to very selfishly ask, my own question to the panel. I'm very curious about the question, and I want to hear what you guys have to think. Okay, now assuming, and maybe this is too big of an assumption, you sell a pack of pens to someone, and on the pens you put a EULA, an end-user license agreement, on the package of pens, or terms and conditions, and it says, just buried in there, you bought your pens, you open it up, and it says anything you write with this pen is owned by us. You write a poem, we own it. Would that be legal, right? Would that be unconscionable? Would that be legal? Would that be upheld? And if it wouldn't be upheld, then why are video game EULAs upheld? Is a mod that someone creates owned by them, even though the EULA says the company owns it?
Is it a Santa Claus business card kind of thing where I can't see the EULA because it's in the teeny tiny print?
Sure.
Well, we are talking about an adhesion contract, right? So I mean, you're definitely in the realm of, if I had to guess, I would think whatever judge first saw that would just sort of say this is unconscionable. It's no way somebody could have actually been expected to think this. People don't read most EULAs. I don't know. To me, I feel like, I just sort of feel like it wouldn't be likely to take a very, what would be the outcome the user would expect, as opposed to taking a very harsh view of what that EULA actually said.
I have a simpler answer, actually. Copyright assignments must be in writing. And if you and there's nothing in writing, you're not signing anything.
it's on his pen.
Well, I haven't signed anything.
Well, yeah,
I haven't signed a pen.
Yeah,
It's
also-
like pen, or
Yeah,
whatever.
when you sign a EULA, you're not assigning rights in any mods that you make to the company. It's the EULAs gives the ability of the company to sue you if you break the EULA, or
No,
it's a little different.
Or turn the service or something.
Yeah, or like
I know
when
what
it
you mean.
So one thing I'm referring to is this whole issue of Dota, of who owned Dota, right? Was it Blizzard that owned Dota because their EULA at the time said, you can mod Warcraft 3, but any mods you make belong to us, and it did. It said that. It said any mods belong to us. I don't know the exact language, but I don't know if it was just, hereby signed or what it was. And then there was the guy that came in and Ice Frog that made it, and Ginsu and all these people. So who owned it? Was it Blizzard? Was it the guy who was Ice Frog, who then later assigned his rights to Valve? I thought it was a very interesting question, and I don't know the answer.
Well, on this general question of the EULAs, this is a really complicated, time-consuming topic to talk about. I mean, one reason why when you open up the video game that you bought at Best Buy, if you still do that, but if you bought it at Best Buy and you open it up and it actually came with a paper instruction book or at least some licensing terms somewhere that you could access. One reason why those are enforceable is because of a case across the street from the 7th Circuit, this Pro CD case. Now, Pro CD is a very well-known contracts case. It's not the only approach, the approach the court took in that case is not the only one that courts follow in these situations, but it was a case where somebody bought a box of software at the store, took it home. There were licensing terms in the box, they flashed up on the screen. The person agreed to the licensing terms by clicking, but the click doesn't seem all that important in that particular case. The court kind of hedges on this for reasons that I think would take too long to explain why I think that might have happened, but the court said by keeping the software, after having had time to look over the terms, giving up the opportunity to get a refund, the court imagined you can get a refund on software you buy it, you can't, but the court pretended you could. By giving up that opportunity, you accepted the terms in the box. You accepted the term of the price of the game, the software on the shelf, $150. There were terms inside the box, one set of terms. By keeping the game, it was not a game. By keeping the software, you accepted that collection of terms. Now, were you really in privity with the manufacturer of the software? Because you didn't buy it directly from them. Sometimes you do, other times you don't. So there were a lot of hard questions in there, and some of these questions were evaded. The answer the court gave became controversial. There is some sense that, yes, people should be bound by some terms that come with software, but it's actually a tough issue for the courts, and they've struggled with it for years to figure out what's the limit here. In your example, I'm sure a court would say your terms aren't binding, although you wonder why. Why don't more companies put on their paper books, as they might on their e-books or something like that, onerous licensing terms? If you ever have a problem with this, you have to arbitrate, class action waiver. Why aren't those on the first page of every book you buy in physical form? I think because there's an assumption courts at some point will say no. We've settled on the enforceability of all these terms that show up with software. But I don't think it'll work for these other products. But I can't think of an example where it's really been tested. Although Wizards came close with Dungeons and Dragons in their open licensing terms.
Or the OGL.
The OGL, right? Open gaming license. So it seemed to me that what that meant was if I go buy a copy of the Dungeons and Dragons rulebook at Barnes and Noble across the street, not from Wizards of the Coast directly, so there's no contract with Wizards, nor is there any point where I'm going to click yes on a little box that pops up on a screen where that might be the assent to the terms. That's not going to happen either. And yet these terms come with the book. I have no relationship to Wizards, only Barnes & Noble. Barnes & Noble didn't impose these terms on me, they don't care. They have no interest in these terms. So would I ever be bound by these terms? Why can't I go and do whatever I want, copy all the game mechanics I want, ignore the license completely? Well, it's never tested in court. But that's one of the few examples where I think somebody went beyond the usual software context and tried to attach this license that would just travel with the product in the way that Wizards wanted the license to travel with their game books.
I've actually got to cut us off there because we're at time. But I was excited by all of those questions. I thought those were super cool.
You asked what we'd like a case. I'd like a case on that.
Case on that?
I want somebody to
Man.
get into a lawsuit with Wizards and see what
With
happens.
Hasbro.
With Hasbro. Open gaming license.
Someone in this room can start it. I guarantee you.
I've been in several arguments with Hasbro about this, but none of my clients want to pay to go against Hasbro.
Okay, well that concludes this panel. We're going to have our last panel of the day coming up in like 2 minutes. We're going to talk about some free speech issues, but in the meantime, help me thank our panelists for this one.